Vellore Citizens Welfare Forum v. Union of India and Ors. In this video, we delve into the landmark case of Vellore Citizens Welfare Forum v. Union of India and Ors, a pivotal moment in Indian legal history. This case analysis explores the significance of citizen engagement and rights advocacy in shaping environmental law and social impact. The Supreme Court's ruling in this 1996 case sets an important legal precedent, highlighting the importance of judicial review in protecting human rights and upholding constitutional law. We examine the Vellore Citizens Welfare Forum's efforts in promoting public interest and the Union of India's response, shedding light on the complexities of legal justice and citizen rights. Join us as we dissect this critical case and its enduring influence on Indian legal history. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family and social groups to spread this knowledge. Join me as I dive deep into the mystery of the Vellore Citizens Welfare Forum case from 1996 and try to piece together what really happened. In today's video, we're going to explore a landmark case that has had a significant impact on environmental jurisprudence in India. The Vellore Citizens Welfare Forum v. Union of India and Ors. Judgment has been a game-changer in the way we approach environmental protection in our country. So, let's get started and see what this case is all about. Nature is superior than all other man-made things in the world. In the contemporary era, environmental protection is important than any profit earned by any company in the world. Therefore, environmental ethics holds important place in Indian philosophy as well as in Indian constitution. After tragic incident of Bhopal gas tragedy, Indian judiciary took great initiative in making environment pollution-free by considering right to pollution-free environment as the fundamental right under Article 21 of the Indian Constitution. Due to this step, environment protection was included in 42nd Amendment by legislature. There are a number of cases in India regarding environmental protection, but the Vellore Citizens Welfare Forum v. Union of India is the most celebrated case because it brought positive approach towards environmental protection laws in India. This case not just focuses on environmental issue, but it covers various legal angles. This case introduced major two principles to India, that is polluter-pays principle and precautionary principle. It also focuses on sustainable development to bring stability between economic gain and environment protection. These principles were also discussed in the cases like Indian Council for Enviro Legal Action v Union of India 5 SCC 281 and Research and Foundation for Science, Technology and Natural Resource Policy v. Union of India Air 2012 SC 2627. Respectively, but they only got inserted in Indian law through Vellore Citizens Welfare Forum case. This article is a case study of Vellore Citizens Welfare Forum v. Union of India along with the importance of CSR principle in today's era. Facts. 1. There was a NGO named as Vellore Citizen Welfare Forum. It has filed a public interest petition under Article 32 of the Constitution concerning severe pollution of soil and water which was causing due to discharge of untreated sewage water from 900 tyrannies built in 5 districts of Tamil Nadu. 2. The Palar River in Tamil Nadu, which was main source of potable water in that area, used for consumption and irrigation, was completely polluted due to this tyrannies. And it is on the verge of extinct now. 3. Then a survey of sewage water was done and also area near tyrannies was checked and it was found that 176 different types chemicals are present in the tyrannies water. 35,000 hectares of land near the tannery was declared unfit for cultivation. Also, water of 350 wells present that area was declared unsafe for consumption. 4. Also, order of the Tamil Nadu Pollution Control Board to build an effluent plant for proper disposal of effluents was left unheard. 1. Issues. 1. Whether principles such as polluter-based principle and precautionary principle, which are the important part of sustainable development, holds any place in Indian law. 2. Up to what extent we can compromise environment safety for future economic development? 3. Whether tanneries should be allowed to keep on working at expense of life of lakhs of people residing there? Judgment. 1. The 3 articles which are dedicated to environment protection in our Constitution are 48A, 51A, 21A. 48A. The state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. It shall be the duty of every citizen of India to protect and improve the natural environment including forests, lakes, rivers, and wildlife and to have compassion for living creatures. 21a. No person shall be deprived of his life or personal liberty except according to procedure established by law. 2. The court cited that in the case of Indian Council for Enviro Legal Action v. Union of India to explain the principle as a polluter-based principle as the absolute liability for harm to the environment extends not only to compensate the victims of pollution but also the cost of restoring the environmental degradation. Remediation of the damaged environment is part of the process of sustainable development and as such polluter is liable to pay the cost to the individual sufferers as well as the cost of reversing the damaged ecology. 3. The precautionary principle defined by the court as the environmental measures taken by the state authorities must anticipate, prevent and attack the causes of environmental degradation. 4. From this court realized that it is high time for the country to realize the importance of environment and to stop damage that is causing to it. 5. Then court gave emphasis on the concept of sustainable development. Court introduced the principle of sustainable development so that development and securing environment can go in hand. They highlighted its international sphere and also stated that it is accepted as customary international law. This principle was first introduced in Stockholm Declaration in 1972. Definition of sustainable principle is given by the Brundtland Report. It states means development that meets the needs of the present without compromising the ability of future generations to meet their own needs. 4. 6. Court further said that conserving natural resources, assistance and cooperation, eradicating poverty, protecting environment, giving financial assistance to developing country, polluter-based principle and precautionary principle are salient features of sustainable development. But court was of the view that precautionary and polluter-based principle forms part of the municipal law. 7. Then the court incorporated precautionary principle and polluter-based principle in Indian domestic law. These two principles were incorporated Article 47, 48A, 51A of the Constitution of India, also an Environment Protection Act, 1986, Water Prevention and Control of Pollution Act 1974 and Air Prevention and Control of Pollution Act 1981. 8. Then government started taking immediate action for pollution in environment. It also put a ban on all industries operating within 1 kilometer of any water resources. 9. Court realized the harm the tanneries are causing to the Polar River. They gave the judgment in favor of Vellore Forum and ordered the tanneries to deposit a sum of 10,000 rupees as fine. 10. Even after tanneries were shut, they set up singular contamination control devices and continue to operate. Then court advised that no tanneries will work unless the fulfillment of the criteria, that is to set up contamination control devices under the guidance of Pollution Control Board. 11. Through Environment Protection Act, 1986 Section 3, court also ordered to always keep eye on the working of tanneries. 5. Precedent set by the case. 1. MC Mehta v. Kamal Nath and Ors. 6. In this case, court applied the precautionary principle and polluter-based principle and orders the accused party to pay the damages for the restoration. 2. P. Pollution Control Board v. MV Nayadu and Ors. 7. In this case, court applied the precautionary principle and clarified on the uncertainty regarding this principle. 3. Bombay Cotton Mills case. In this case, court relied on the principle of sustainable development and emphasizes on the balance between the economic development and environmental protection by referring Vellore case. 8. Analysis. The Vellore Citizens Welfare Forum v. Union of India is the very significant judgment in the concerning environment protection. This judgment recognizes the right to pollution-free environment by incorporating the two international principles, that is, environment protection and polluter-based principle, in the Indian law. Even if this judgment brought many good changes and new rules regarding environment protection, but there are drawbacks in the way these new rules and law was adopted and enforced. Court, in order to resolve the big conflict between protection of environment and future development, took the sustainable development as its approach to deal with the issue, but court did not provide proper measure regarding how this concept will work and maintain balance between the two aspects to achieve the goal. The justification provided by the court while adopting this path in securing the environment is erroneous and based on controversial grounds. Court has ordered tanneries to shut down and install the contamination control devices and ordered the authorities to look into its working. Whether the implementation of the same is actually done or not is questioned, and whether it is implemented today also, 20 years after the judgment, is a great concern. Government has to look on the implementation of certain measures given by the court, otherwise the whole judgment will be of no use. Court also paved down the way for sustainable development through this case and realizes the importance of environment. But courts has to look on whether this principle is actually implemented and whether companies are carrying CSR activities to contribute towards the environment. Drawback of the judgment. 1. Court incorporated the polluter-pays and precautionary principle but did not give the guideline for the enforcement of the same. 2. Court also did not clarify that whether precautionary principle and polluter-based principle form customs. 3. Court incorporated these principles through Article 47, 48A, 51A of the Constitution of India, but on the plain reading of these articles they only state state responsibility for maintaining healthy environment, and does not clear that how these principles can be incorporated in domestic laws. 4. Court ordered tanneries to pay fine, but it did not mention the grounds on which liability is to be fixed and did not give the mechanism to derive individual liability. Therefore, when after some years analysis is done, it was found that court's orders were not fully implemented and followed by the committee. Suggestions. 1. We can make eco-friendly practices like going paperless, making eco-friendly products, recycle process mandatory for all companies. 2. We can give specific sustainable development goal to each company to ensure faster results. 3. We can organize seminars and conference on specially for companies on CSR and sustainable development to encourage more companies to adopt these practices. 4. We can make the laws and provisions strict regarding non-compliance of the targets. 5. We can give assistance to companies who are falling short in achieving their targets. Sustainable development and corporate social responsibility. 1. The European Commission defines CSR principle as a concept whereby companies decide voluntarily to contribute to a better society and a cleaner environment. 2. World Commission on Environment and Development defines sustainable development as development that meets needs of the present without compromising the ability of future generation to meet their own needs. 3. The CSR principle is very important to maintain the balance between the damage caused by companies and securing environmental protection. 4. India is the first country to provide statutory mandate of CSR. Carrying out CSR activities is compulsory for Indian companies as per Section 135 of the Companies Act 2013. It is mandatory for the companies to spend their 2% of average net profits of previous 3 years on CSR activities. 9. 5. As per the Section 135 of the Companies Act 2013, CSR principle is applicable on the companies whose annual turnover is 1,000 crores and more, companies having net worth of 500 crores or more, and companies having net profit of 5 crores or more. 6. Schedule 7 of the Companies Act provides with the list of all the activities that comes under the ambit of CSR principle, and ensuring environmental sustainability is one of them. 7. On July 26, 2019, the Lok Sabha passed the Companies Act Bill 2019, in which they have clearly mentioned that company which will fail to contribute towards CSR activity will face fine and also imprisonment in some cases. 10. 8. A decade ago, the CSR activities carried out by the companies were mostly in relation to environment like plating tress, installing solar plants, but now they are carrying out activities of deforestation and degradation to win the race of earning maximum profit. 11. The case of Vellore Citizens Welfare Forum v. Union of India and Ors is a landmark judgment by the Supreme Court of India, which highlighted environmental concerns, particularly focusing on the pollution caused by industries and the enforcement of sustainable development principles. Below is a detailed explanation of the case. Background of the case. Context: the Vellore district in Tamil Nadu, India, is known for its leather tanning industry. While this industry contributed significantly to economic development, it also caused severe environmental damage. Effluents containing toxic chemicals such as chromium and other pollutants were discharged directly into water bodies, resulting in contamination of rivers, agricultural lands, and groundwater. Petitioners: the case was brought as a public interest litigation by the Vellore Citizens Welfare Forum, representing residents of Vellore who were adversely affected by the pollution. Respondents: the Union of India, the Tamil Nadu government, and tannery operators were named as respondents. Key issues. 1. The unchecked discharge of untreated effluents by the tannery industries. 2. The adverse impact of pollution on human health, agriculture, and the environment. 3. The need to balance economic development with environmental protection, as enshrined in the principle of sustainable development. Legal arguments and principles involved. 1. Fundamental right to life. The petitioners argued that environmental degradation violated the citizens' fundamental right to life, which includes the right to clean water and a pollution-free environment. 2. Environmental protection under directive principles. Article 48A directs the state to protect and improve the environment, while Article 51A imposes a duty on citizens to protect the natural environment. 3. Polluter-pays principle. This principle, widely recognized in environmental jurisprudence, mandates that the polluter should bear the cost of preventing and remedying environmental damage. 4. Precautionary principle. This principle, crucial to sustainable development, requires that preventive measures be taken when an activity poses a potential risk to the environment, even if conclusive evidence of harm is lacking. 5. Doctrine of sustainable development. The case emphasized the need to balance economic growth with environmental protection, ensuring that the development meets the needs of the present without compromising the ability of future generations to meet their own needs. Judgment by the Supreme Court. The Supreme Court delivered a comprehensive and landmark judgment in this case. Key aspects of the judgment include: 1. Recognition of sustainable development. The court unequivocally recognized sustainable development as part of Indian law and emphasized that development and environmental protection must go hand in hand. 2. Application of the polluter-pays principle. The court held that the tannery operators were responsible for the environmental damage caused and directed them to pay compensation to affected individuals and restore the damaged environment. 3. Environmental monitoring and compliance. The court directed the Tamil Nadu Pollution Control Board to ensure that tannery industries installed necessary pollution control measures, such as effluent treatment plants. Industries that failed to comply with environmental standards were ordered to be shut down. 4. Establishment of a green bench. The court suggested the creation of specialized environmental courts or benches to deal with environmental matters more effectively. Impact and significance. 1. Strengthened environmental jurisprudence. The judgment reinforced the applicability of the principles of sustainable development, polluter pays, and precautionary action in India. 2. Focus on industrial responsibility. Industries were made accountable for environmental degradation, emphasizing the importance of pollution control measures. 3. Precedent for future cases. The case became a precedent for subsequent environmental cases in India, such as Indian Council for Enviro Legal Action v. Union of India and MC Mehta v. Union of India. 4. Public awareness. The case heightened public awareness of environmental issues and encouraged activism to protect the environment. Critical analysis. Strengths. The judgment was a progressive step toward integrating international environmental principles into Indian law. It highlighted the judiciary's proactive role in environmental protection. Criticism. Despite the judgment, enforcement remains a challenge due to bureaucratic inefficiency and lack of industrial compliance. Critics argue that the polluter-pays principle should be applied more rigorously, and compensation mechanisms should be more transparent. The case revolves around the environmental challenges faced by the people of Vellore, a city in Tamil Nadu, India. In the 1980s and 1990s, Vellore was struggling with severe environmental pollution due to the establishment of numerous tanneries in the region. These tanneries were releasing massive amounts of toxic waste into the environment, contaminating the water and soil, and affecting the health of the local population. The people of Vellore were facing severe health issues, including skin diseases, respiratory problems, and even cancer. The situation was so dire that the citizens of Vellore came together to form the Vellore Citizens Welfare Forum to fight against the environmental degradation caused by these tanneries. They realized that the only way to address this issue was to take legal action against the Union of India and the Tamil Nadu government. The Vellore Citizens Welfare Forum filed a petition in the Supreme Court of India, alleging that the tanneries were violating the fundamental right to life guaranteed under Article 21 of the Indian Constitution. They argued that the right to life includes the right to a healthy environment, and that the government had a duty to protect the environment and the health of its citizens. The forum also contended that the tanneries were operating without any regard for the environment, and that the government had failed to take adequate measures to prevent pollution. They sought the closure of all tanneries that were operating without proper pollution control measures and compensation for the victims of pollution. The Union of India and the Tamil Nadu government, on the other hand, argued that the tanneries were providing employment to thousands of people and contributing to the state's economy. They claimed that the pollution caused by the tanneries was not as severe as claimed by the forum, and that the government had taken steps to mitigate the environmental impact of the tanneries. The Supreme Court, however, disagreed with the government's stance. The court held that the right to life guaranteed under Article 21 of the Indian Constitution includes the right to a healthy environment, and that the government has a duty to protect the environment and the health of its citizens. The court also recognized the principle of sustainable development, which involves balancing economic development with environmental protection. The court noted that the tanneries were operating without proper pollution control measures, and that the government had failed to take adequate measures to prevent pollution. The court directed the government to take immediate steps to prevent pollution from the tanneries, including the closure of all tanneries that were operating without proper pollution control measures. The Supreme Court's judgment in the Vellore Citizens Welfare Forum case marked a significant shift in the way environmental issues are addressed in India. The court's recognition of the right to a healthy environment as part of the right to life has had a major impact on environmental jurisprudence in our country. The polluter-pays principle, which was first recognized in this case, has been widely accepted as a fundamental principle of environmental law. This principle holds that the polluter is liable for the damage caused to the environment and must pay for the costs of remediation. The case has also had a significant impact on the way the government approaches environmental issues. The government is now more aware of its duty to protect the environment and the health of its citizens, and has taken steps to strengthen environmental regulations and enforcement mechanisms. The Vellore Citizens Welfare Forum case is a testament to the power of citizen activism and public interest litigation. It shows that ordinary citizens can come together to fight for their rights and protect the environment, and that the judiciary can play a vital role in upholding the rights of citizens and protecting the environment. The Vellore Citizens Welfare Forum case is a cornerstone of Indian environmental law. By addressing industrial pollution and emphasizing sustainable development, it set a high standard for environmental protection in India. The case continues to influence judicial decisions and policy-making in environmental matters. This case is in relation to environment protection, but it holds equal importance in corporate law too. Economic benefit is very important for industries, but securing environmental is the need of today's hours. This case gave the concept of sustainable development, which strikes balance between both. This case ultimately shows that environment could not be compromised at any cost. In conclusion, the Vellore Citizens Welfare Forum v. Union of India and Ors. Judgment is a landmark case that has had a significant impact on environmental jurisprudence in India. It has established the right to a healthy environment as part of the right to life, and has recognized the principle of sustainable development in the polluter-pays principle. The case is a reminder that environmental protection is not just a moral obligation, but a legal duty that must be upheld by the government and the judiciary. It is a call to action for all of us to come together to protect our environment and ensure a sustainable future. So, what do you think about the Vellore Citizens Welfare Forum case? Do you think it has had a significant impact on environmental protection in India? Share your thoughts in the comments below, and don't forget to like and subscribe for more videos on landmark judicial decisions.